Okay, this is the 100-120 class. This is some material from the Court Reporter's Handbook. For the record, who is the person who sits in front of the courtroom, usually between the judge and the witness, furiously tapping his or her fingers on a strange-looking keyboard? Who is the person who walks into a crowded room filled with lawyers and potential witnesses and calmly takes control of the situation? Who is the person responsible for having closed captioning appear at the bottom of millions of television screens across the nation? Who is the person upon whom the entire justice system depends for the preservation of a true and accurate record? Let us see who are the court reporter and real-time reporters of the world today. Court and real-time reporters come in a variety of shapes and sizes. They are both male and female. They are young and old. They represent a variety of nationalities, affiliations, and faiths. Court reporters are a diverse group of individuals who have many differences in appearance and demeanor, but they all have one thing in common. They record and transcribe in a professional and competent manner. Usually, you will find that court and real-time reporters have an attitude to succeed. This quality is first exhibited when the reporter is in school, studying and practicing. Reporters do not give up. When things get tough and difficult, they usually find a way to accomplish monumental tasks. The attitude of success is not a domineering, overbearing, pretentious attitude that engulfs a person's whole being, but rather it is an attitude of, I know I can do it, and I will do it. Court and real-time reporters have a strong will to persevere and hang in there. Their actions and what they choose to do with their lives will certainly depict their determination, grit, and perseverance. In a very real sense, they are a stubborn people in the sense that they don't quit. A sense of confidentiality accompanies the profession of court and real-time reporting. A universal rule among court reporters is that they never, ever mention what goes on in a courtroom when they are outside the courthouse. This same maxim holds true for all proceedings, legal or non-legal. Reporters realize the ethics of not telling other people what transpires at a deposition, trial, or hearing. Even when the record is public, the reporter still maintains a sense of confidentiality about what happened. Furthermore, reporters remain impartial and unbiased even in the most gruesome and heinous cases. Court and real-time reporters exhibit a great deal of respect and courtesy toward the judge and the lawyers. The reason for this respect is not because it is demanded or required, but rather because it is a respect that has been earned by lawyers and judges. In the same sense, the legal profession has high regard for those dedicated professionals who work in the field of court reporting. Reporters are willing to work with judges and lawyers in almost any type of environment. Although most working situations are compatible, sometimes personality conflicts and clashes arise. The reporter will always maintain a sense of decorum and courtesy toward the bar. Court and real-time reporters also have very high regard for their employers and fellow employees. They know what is required to become a reporter and therefore respect and admire other people who have endured the stringent educational requirements in order to become a professional reporter. Tact is the ability to handle a delicate situation. Court and real-time reporters possess a certain amount of tact when dealing with lawyers, judges, or clients. Their tactfulness and diplomacy imply a sense of self-control and discipline that most people do not possess. Most court and real-time reporters exhibit a deep sense of loyalty both toward their profession and toward their employers. Reporters are a loyal bunch. This faithfulness is due in part to their keen sense of commitment and dedication, but there also exists a very strong comradeship and esprit de corps among reporters. Court reporters pride themselves on giving a full and honest day's work for their pay. They also take great pride in their finished work product, the transcript. For the court reporter, being on time is being 30 minutes early. Reporters realize this rule and know that a great deal of preparatory work must be done before a deposition begins or a trial starts. A reporter will not walk in 2 minutes before the examination is to begin and start setting up his or her equipment. Rather, an efficient reporter has already set up and started to gather some of the preliminary information that is essential to getting an accurate record. Court and real-time reporters must be honest and possess a certain amount of integrity. Lawyers and judges know whom they can trust, and 9 times out of 10, they are going to turn to the court reporter as a trusting and loyal companion in the judicial process. Okay, continuing on, court and real-time reporters must be accepted as individuals who possess an honest and forthright disposition. If not, clients will have difficulty trusting the accuracy of the record. Of all the professions in the world, perhaps the most trusted and honored is the profession of court and real-time reporting. So who are court and real-time reporters? They are people who know what they want in life, work for it, and then do it. They are people who work hard at what they do and get paid well for it. They are professionals who take pride in a job well done. Court and real-time reporters are people who provide a valuable service to the judicial process and to humanity. This brief description of who court and real-time reporters are may sound as though only super extraordinary men and women need apply, but such is not the case. The most important thing to remember is that court reporters are ordinary, everyday human beings. Court and real-time reporters are people like you. You could be a court and real-time reporter. What exactly does a court and real-time reporter do? Well, to begin with, we know that he or she records what is being said and then transcribes it. Is this all that he or she does? Does this really describe the entire job of a court and real-time reporter? Yes and no. True, the bottom line is to capture what is being said using a shorthand system that will record notes on paper tape and in some cases onto a magnetic media, and then to produce an accurate transcript of what was said. However, few people realize what really goes into producing that accurate record. Briefly, the job of a court reporter can be divided into two broad categories, writing and reading. In being able to capture the spoken word, a court and real-time reporter must know a system of shorthand writing that he or she can use with confidence and assurance. A reporter must know the system thoroughly and be able to write words that he or she has never heard before by using a phonetic system of writing words. At the same time, a reporter must be aware that what he or she writes may be instantly transcribed. Therefore, the pressures of error-free writing are constantly overshadowing the role of a reporter. Okay, this is some literary material for the record. Since 1920, the primary objective of vocational rehabilitation has been to provide rehabilitation services which assist physically and mentally handicapped individuals to become employable. Over the last few years, the poorer and more rural states of this country have made commendable progress in the vocational rehabilitation field. We have for years suspected, and the Social Security Administration Office of Research and Statistics has confirmed, that proportionately more disabled persons live in the South than in any other region of the country. Many of these states have responded to this situation with strong state and local support of rehabilitation efforts. An indication of this support is the fact that many of these states have, for the past 6 years, overmatched their federal rehabilitation funds. Most have organized and are operating cost-effective and highly successful programs. Others are just beginning. I am proud to say that as a result of very hard work and careful organization, South Carolina has, for the past 4 years, operated the most successful rehabilitation program in the nation. Last year, South Carolina rehabilitated 659 per 10,000 disabled persons. South Carolina also led the nation in the percentage of severely disabled persons who are now working as a result of rehabilitation programs. Commendation of state efforts is not to say that the federal dollar is not important in South Carolina. It is most important. It is absolutely essential. It is my intention to only point out that in South Carolina, the federal dollar is not only needed, it is well spent. South Carolina spends approximately $1,600 to rehabilitate an individual. California spends $6,000 to rehabilitate a similar individual. Now, with the change in formula instituted by Section 105B, we are proposing to take from those who need federal dollars the most and are using this money efficiently and successfully, and give these dollars to the states which need it least, and which in many cases see far less results from the money they already have. In the last few years, there has been feeling among the more populous and more wealthy states that there should be a change made in the formula for allocating rehabilitation monies. These states do, in fact, receive less per capita in vocational rehabilitation funds. However, the purpose of vocational rehabilitation is not to serve the needs of the general population of this country. The services are designed strictly for physically and mentally handicapped individuals who are potentially employable. The JWK study commissioned in 1937 stated emphatically that the total resident population is not the best measure of the potentially disabled population. That total population includes large groups that are not or unlikely to be part of the target population. Now, the very members of this body who were instrumental in seeing that HEW study the formula question are ignoring a very significant part of that analysis. Okay, this will be some legal material for the record. Mr. Foreman and ladies and gentlemen of the jury, you have heard all of the testimony in these cases. You have heard the arguments or the summations of the attorneys. It now becomes my duty to state to you the law that applies to cases of this type. It is your duty to make a determination of the facts in the case. It is for you to decide or determine just what did or did not happen. You apply those facts as you find them to be to the law, as I shall state it to you, and thereby arrive at a proper verdict. Now, under the laws of our state, I am not permitted to comment upon the facts in the case. You, the jurors, are the sole and exclusive judges of the facts in each case. The facts are for your consideration. The facts are for your determination. I am satisfied that you are fully capable of determining them. As I have just stated to you, it is my duty under the laws to state to you the law that is applicable to the case in order that you may apply the facts as you find them to be and render a proper verdict. It would be a violation of your duty to attempt to determine the law or to base a verdict upon any other view of the law than that given to you by the court, a wrong for which the parties would have no remedy, because it is conclusively presumed by this court and by all higher courts that you have acted with these instructions as you have been sworn to do. So, Mr. Foreman and ladies and gentlemen of the jury, you are here for the purpose of trying the issues of fact presented by the allegations in the indictments and the plea of not guilty of each of the defendants. This duty you should perform uninfluenced by pity for the defendants or any one of them, or by passion or prejudice on account of the nature of the charges against them. You are to be governed, therefore, solely by the evidence introduced in this trial and the law as given to you by the court. The law does not permit jurors to be governed by mere sentiment, conjecture, sympathy, passion or prejudice, public opinion or public feeling. Both the state and the defendants have a right to demand, and they do so demand and expect, that you will carefully and dispassionately weigh and consider the evidence and the law of the case, and give to each your conscientious judgment, that you will reach a verdict that will be just to both sides, regardless of what the consequences may be. Now, the offense with which these defendants are charged in these indictments is that of conspiracy, of arson, and of burning personal property to defraud an insurance company. And in this connection, Mr. Foreman and ladies and gentlemen of the jury, I instruct you that these indictments are mere charges or accusations against these defendants. It is not any evidence of the defendant's guilt, and no juror at this stage should permit himself or herself to be influenced against the defendants because of or on account of the indictments. It is the duty of the jury to decide whether the defendants or any one of them be guilty or not guilty of the offenses charged, considering all of the evidence submitted to you in this case. Now, Mr. Foreman and ladies and gentlemen of the jury, you are the sole and exclusive judges of the effect and the value of the evidence addressed to you. You are also the sole and exclusive judges of the credibility or believability of every witness who has been sworn, who has taken the stand, and who has testified in this case. It is for you to say what weight, what belief you shall put in the testimony of every witness. Now, in making that determination, take into consideration the fact as to whether they have spoken the truth. You look only not at the manner of the witnesses while on the stand, their reaction to the case, if any, but also their degree of intelligence. Every witness is presumed to speak the truth. This presumption, however, may be rebutted by the manner in which the witness testified, his interest in the case, if any, or any bias or prejudice, if any, against one or any of the parties, by the character of his testimony, or by evidence affecting his or her character for honesty or integrity, if any, or by contradictory evidence, if such there be. And again, Mr. Foreman and ladies and gentlemen of the jury, you are the exclusive judges of the believability of every witness who has been sworn, who has taken the stand, and who has testified in this case. And again, in passing upon the credibility or believability of witnesses, and in deciding what weight you shall attach to their testimony, you must consider all of the circumstances, their opportunity for knowing what they testify to, their conduct and demeanor upon the witness stand, the influences under which they testify, the inducements held out to them, and everything which is calculated to bias and influence their views and judgment. And then you say what weight you will give to their evidence or testimony. I further charge you that the testimony of a witness may be discredited or impeached by showing that the witness has been convicted of a crime involving moral turpitude. Now, prior conviction does not render a witness incompetent to testify, but is merely a circumstance which you may consider in determining the credibility or believability of that witness. It is the province of the jury to determine the weight to be given to any prior conviction as impeachment. And as I stated to you, it is your responsibility to determine and to decide what weight you shall attach to the testimony of every witness.